Good morning. Can everybody hear me okay?
Yes.
And Miss Federico, are you ready to go?
Yes, I am.
And Miss Wiesenthal?
Yes, I am.
Okay, we are on the record in the Colorado Public Utilities Commission's proceeding number 24A-0560E. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is approximately 9 a.m. on May 15th, 2025, and this remote hearing is being webcast. This remote hearing was scheduled in decision number R25-0336-I dated May 1st, 2025. I will take appearances now, starting with public service.
Good morning, Your Honor. On behalf of Public Service, this is Caitlin Shields from the law firm Wilkinson Barker Nauer. With me are Chris Irby from Public Service Company of Colorado, as well as Lauren Caliendo. And I would also note, as we had indicated in the motion, we do have a couple of subject matter experts who are available.
Understood. Thank you and welcome to all of you. Let's move on to staff.
Morning, Your Honor. Assistant Attorneys General Justin Cox and Aileen Chong with the Colorado Attorney General's Office on behalf of trial staff of the Commission.
Thank you and welcome. Let's move on to UCA, please.
Good morning, Your Honor. Kate Crampton with the Attorney General's Office on behalf of the Utility Consumer Advocate. I'm also joined by my colleague, Tom Dixon.
Thank you and welcome. And how about Tri-State Generation Transmission Association?
Good morning, Your Honor. Dietrich Hefner of the law firm Womble Bond Dickinson on behalf of Tri-State.
Thank you and welcome. And finally, how about CIEA, and is there anybody here from there? All right, not seeing anybody, so we will move on. So as I noted, this remote hearing was scheduled in decision number R25-0336-I. As stated in that decision, the purpose of this hearing is to address whether extraordinary circumstances exist justifying a further extension of the statutory deadline of up to 130 days for a final commission decision in this proceeding pursuant to section 40-6-109.5 subsection 4 of the Colorado Revised Statutes. Yesterday, Public Service filed a motion for variance from some of the requirements in decision number R25-0336-I, which provides another purpose for this hearing, specifically to discuss the variances from that decision requested by Public Service, and as well as the proposed procedural schedule proposed in that motion. So with that, I thought that what I would do initially is address the motion for variance and give my reaction, give any opportunity to any other parties to respond to it if they so choose. I think UCA is the only one I think that expressly at least reserved the right to respond to it. So but why don't we start there? Why don't I see if anybody wants to respond to the motion for variance at this point. Ms. Crampton, I see you put your hand up. Why don't you go ahead?
Yes, thank you. I just want to clarify UCA's position that was noted in the conferral portion of the statement. From UCA's perspective, we asked for leave, for an opportunity for leave to respond, because fundamentally we need more time to understand the company's variance motion. We received the motion in the afternoon of the 13th. I didn't receive it until yesterday morning, but I think that was just an error that I wasn't included. But fundamentally, we had less than 24 hours to react to this motion for the request for a variance. And I think in some circumstances, we can look at the issues and make a quick decision. But this motion and the requested variances appear to be fairly substantive. And also, I think there's a shared lack of clarity, even from the company, about understanding what the court had ordered in its interim decision. For example, in the company's motion, I think it's paragraphs 19 and 20, there's sort of a discussion about their interpretation of the of your order, but are a little unclear whether the court had intended to order alternative transmission scenarios. And so I think kind of the first step from our perspective is to get clarification from the court about what it meant with its order, and what it was originally asking to be modeled. I think if the answer is from the court is yes, we were asking for these alternative scenarios to be modeled. In UCA's position, these requested variances are a pretty significant departure or significant departure from what the court may have contemplated. And I think where that leaves us as UCA is needing more time to then understand what the impact of these requested variances are. And just given the timing of the motion, the work that we tried to do internally at UCA to kind of understand these requests, we simply haven't had enough time. I say this because my read of a lot of the requested variances is to not have alternative scenarios modeled, but rather take the company's sort of chosen modeled portfolio and then just model sensitivities against that. And so it kind of begs the question, is this sufficient and adequate to meet CPCN requirements? Is it sufficient and adequate to meet what the court had intended with this? And quite frankly, we just need more time. I think, to me, then the motion also raises sort of a broader issue, which is, and I say this based on some discovery questions of UCA in this case, but I think the broader question is it the company's position that no alternative scenarios can ever be modeled, whether requested by the court or requested by a party in discovery, and UCA would need time to sort of contemplate that issue as well. So at this time, we oppose, but really we are seeking leave to respond. What I would envision is having a meeting with the company to understand what these alternative scenarios that they're proposing or these variances look like, what the impact is, and how they satisfy what we think the court's order is. And so that would be a meeting that would take place between UCA and the company, and then we could file a written response. So that's our position. And I just wanted to clarify because I don't think that came through in the brief statement of conferral.
Understood. And so I'm not seeing anybody else jump up, and I'll just say, I mean, my plan here today is to effectively provide the clarification that I think UCA is looking for in terms of what decision number R25-0336-I requested public service to do. So I agree with you, Ms. Crampton, that in the motion for variance filed yesterday, it kind of posits two possible interpretations of what I was requesting, one of which was requiring public service to come up with, I think their words were alternative transmission portfolios. So why don't we do this? I mean, my plan is to address the motion for variance. I'm going to initially provide clarification about what I ordered in decision number R25-0336-I for public service to do. Then based on that, I'll come full circle back to you, Ms. Crampton, and see if you would still like additional time to respond to the motion for variance. So that's my plan. But before I launch into the motion for variance, let me see if there's anybody else who wants to weigh in on that motion.
Your Honor, if I may briefly, we very much appreciate your openness and willingness to provide some clarification, and I would indicate we would probably like the opportunity to be able to engage in some discussion around your clarification and your request, just to make sure that we understand and can have an open discussion about what's within the bounds of feasible and reasonable. And hopefully I'll be able to come away with a shared mutual understanding and direction on what the company is actually capable of doing.
Okay, thank you. So with that, let me just launch into the motion for variance and its implications with respect to the decision numbered R25-0336-I. So one theme in that motion was basically the interpretation of my decision of what I was requesting public service to do. And the proposed alterations to the topics for supplemental direct testimony, the alterations proposed to public service, at least in large part, were premised on the proposition that decision number R25-0336-I requested public service to develop multiple alternative transmission portfolios. That's the language that was used. I think we all understand it. So I'm not going to elucidate that concept anymore, but essentially different portfolios of transmission upgrades and what's been proposed in the application. Let me just say that that was not the intention of the decision. Now, to be sure, I think there's a good chance that the record would benefit from such evidence of, other alternative transmission portfolios. So I think the record could potentially benefit from that. But it wasn't my intent in decision number R25-0336-I to require public service to do that. And moreover, public service has stated in the motion for variance that to the extent I did ask for multiple alternative transmission portfolios, that there's no way it could provide that evidence in this record. Frankly, they didn't put it this way, but absent a waiver of the statutory deadline. So it would require a significant amount of time for them to do that. I think they say in the motion for variance that it took them approximately a year to come up with the transmission portfolio proposed in this application, by way of suggesting that that's the time frame that they would need to develop any additional alternative transmission portfolios. Obviously, I have no evidence to the contrary on the timing, so I have to accept that. So, and what I've heard Public Service saying in the motion for variance is that in any event, they could not produce the evidence for alternative transmission portfolios, even if I extend the deadline for a final decision in this proceeding by the extra 130 days permitted by Section 40-6-109.5, subsection 4. So that's the slight background and clarification, and I'll go just slightly further and just say, as to the first topic for supplemental direct testimony, at a higher level of generality, what I'm looking for is an analysis of how often the overload shown in Appendix B to Hearing Exhibit 103 and Attachment AWS-1, Rev 1, how often those overloads occur. That's really the general point of the first topic for additional supplemental direct testimony. The analysis is essentially and provides us the data about how extensive the overloads are forecast to be during peak demand, but we don't know how often they would occur, whether it's 1 hour a year, 20 hours a year, or 1,000 hours a year. The record just doesn't reflect that. And such information is certainly relevant to understanding the degree of the need for the upgrades requested in the application. So, I provide this clarification by way of supporting what I said earlier, which is certainly the first topic, I don't think really even implied that it was seeking Public Service to come up with alternative transmission portfolios. The second topic requires Public Service to use alternative dispatch assumptions to analyze the impact of those assumptions on the overload shown in Appendix B. In other words, what would happen to the overloads shown in Appendix B if the dispatch assumptions were altered, so that thermal generation and storage were used to a greater degree to balance load and renewable generation is curtailed as necessary. So that's, in a nutshell, what the second topic is looking for. And again, I don't think the second topic, it was not intended. And, I think it's a fairly liberal reading, frankly, to say that the second topic was requiring Public Service to come up with alternative dispatch portfolios. And then the third topic, really seeks to understand, okay, if with the second topic, we're looking at changing the dispatch assumptions used in Public Services analysis for purposes of generating, the overload shown in Appendix B, what is the impact then of using those alternative assumptions on Public Service's ability to comply with its statutorily required emission reductions. So that's the general point of the third topic. Again, not requiring and wasn't intended to require public service to generate and provide alternative transmission portfolios. And let me just say, I mean, I'm trying, what I want you to do is really rely on the record from the technical conference and what is written in decision number R25-0336-I, for purposes of determining what you need to do in the supplemental direct testimony. I'm just trying to provide clarification here. So to the extent anything I've said here contradicts something, in that decision, I want you to rely on that decision. And if you have any questions, I'm happy to try to answer them here. But that's where things stand. So let me see. I can also weigh in on the proposed variances requested. And I'm prepared to rule on the motion for variance at this point. But let me stop there first and see whether, in particular, Ms. Crampton, UCA still want an opportunity or some time to be able to respond either here or later in writing to the motion for variance.
Our request would be for leave to respond in writing to the variance motion.
Okay, and earlier you had basically proposed a process of discussion with public service, and then a response in writing. I mean, I think I've provided the clarification that you are seeking.
Yes, it's helpful. Thank you.
Yeah, and I'm not looking for thanks. I'm just trying to understand the need for additional time to respond in writing. I mean, the bottom line is I'd like to get the proceeding moving. So how much time do you think you need?
Understood. I think what I had envisioned was 7 days, 7 calendar days. We could meet with I think we just need a little more time to understand the impact of their request.
Okay, and so the impact of their request is clarified by me. It sounds like maybe it has implications for discovery that UCA has out there. Is that in part what you're trying to understand?
Yeah, I think that's true in part. I mean, I understand what the court has ruled with respect to its intention. Some of the company's statements about what they can and cannot do, I think relate to our advocacy, our discovery, just understanding sort of what is in bounds or what the company believes is in bounds and out of bounds for these types of requests, I guess. So I understand. I mean, I can appreciate that the company needed time after the court's order to have, their own understanding and meet with their folks to see what was possible. I'm just asking for some time on our end. I don't think we need more than a week. And I understand the court's desire to move this case along. I think with respect to the procedural schedule that we've proposed, I think a week for us to have leave to respond is appropriate.
Understood.
Your Honor, if I may respond, and excuse me, I'm not trying to cut you off.
Go ahead, Ms. Shields.
So first I would say thank you very much for the clarification. I think that does help us. in light of the clarification, I do think we continue to stand by the motion for variance as requested. I think the requested modifications align with the clarification that you have given us. I would also note, earlier you mentioned kind of your understanding of your read on our motion as far as the notion of alternative transmission portfolios. And I think that was accurate. The company's position is that we cannot develop alternative transmission portfolios within a reasonable amount of time or within even the 130-day extension that I would anticipate is likely to be found today. Even executing the additional modeling, if the motion for variance is granted today, will take significant time for the company to prepare and develop. So we do have some concerns if UCA is afforded an additional week or 2 weeks without the certainty on our end of the scope of modeling that will be needed, that may further impact the procedural schedule in this case and our ability to comply with the amended procedural schedule that we laid out in the motion. So we are happy to meet with UCA and discuss their concerns, but I do have concerns with our ability to comply with the amended procedural schedule that we set forth in our motion filed yesterday. If we need to wait an additional 1, 2, or 3 weeks for a decision granting the variance and providing us the clarity that we need to move forward with the modeling. We have subject matter experts who are on this call and who are ready to begin the modeling that is needed and to begin those runs as early as today. But we are reluctant to move forward until we have the degree of clarity that we need as to the scope of modeling that needs to occur.
Okay. And let me just say, I hesitate to do this, but so starting a week from today, I'm going to be out of the office for 2 weeks. So Ms. Crampton, you know, I'm inclined to give you some time to respond in writing, but not a whole heck of a lot. I feel that I need to, you know, issue a decision because time is already tight, even if I extend by 130 days. So I'm going to need to issue a decision before, well, on or before next Wednesday. So I would need, if you really want a written response, I would need it by Monday at noon at the latest. So again, I'll come back to you and see if you still want it. It may be that your calendar just won't allow you to do that. So I'll come back to you and so go ahead, Ms. Crampton.
I've sort of made my record. I understand the company's position and I understand the court's position. However, I quite frankly, I think that this is it's quite frustrating to be presented this motion, given less than 24 hours to react, and then less than a week to respond, when fundamentally we're just seeking an opportunity for more understanding. And so that we can state our position for the record, if this does raise broader implications about what is and is not possible in transmission modeling, that I think should impact sort of the scope or weight of evidence that the court will have available ultimately to it in making a decision. So I've requested a week. I understand the court's position. We can accept Monday at noon, though that is not our request.
Understood. Thank you. And let me come back to Ms. Shields, and let me just ask you this, Ms. Shields. So there is a at least the appearance of an inconsistency in what you told me in the motion in terms of timing of this new modeling, and what you've told me today, and what was said at the technical conference. I mean, I think at the technical conference, we had specified fairly well, I think anyway, what the type of information we were looking for. We had discussed how much time public service would need in order to do the modeling that we were at least asking questions about. And I think we were told 2 to 3 weeks. We're hearing now that I think it would take substantially longer for public service to do that modeling. Is my at least impression correct in your view? And if so, can one or more of your subject matter experts give us some explanation for that apparent inconsistency?
Yes, and I'd be happy to turn it over to Mr. Pascucci. I would say from my legal perspective, I think perhaps where the difference has been in terms of the precision of the specific types of modeling requests that were discussed, I think, more conceptually and theoretically at the technical conference. And then two, the level of precision and the specificity that was requested within the actual written decision. And I think what we are representing today is I have no desire to be inconsistent with the motion that was filed yesterday and with our specific request there. But I think it's probably just probably the degree of precision and clarity that had been indicated in the recommended decision. That said, Mr. Pascucci is available. And before we get there, what I would indicate is, it's certainly our desire when we go through these conferral processes to give parties a reasonable amount of time to respond. I will represent that we have had daily multi-hour long dialogues going on with subject matter experts, including third-party consultants, to try to develop a workable approach. And so I would say this has been a high priority for the company, and we have spent many hours trying to get to the proposal and the motion for variance to do the best job that we can to come up with a path forward that can accommodate the timelines that are set forth in this case, while also meeting the objectives that we are interpreting from your decision. So with that, Mr. Pascucci is available to talk a little bit more about some of the modeling challenges and timeline.
Okay, thank you. And welcome, Mr. Pascucci, again. And please go ahead.
Good morning, Your Honor. Thanks to provide a little bit of context. I think where the misunderstanding may have aligned is when we talked about 2 to 3 weeks, we understood that in the context of running a power flow model. So running some power flow models to see, I think, some of those alternative overload scenarios is about 2 to 3 weeks. But in order to layer in those secondary analyses that you were talking about with respect to topic 2 and topic 3, in sitting down with the team, as Ms. Shields alluded to over the last week for several hours, we think we'll need to also run encompass modeling with that. And that encompass modeling can often take just 2 weeks in itself to run one model run. It's a very challenging process to do. And so we think to run all the subsequent models we need to do based upon kind of the layering approach we're taking to looking at how each tranche of projects impacts our ability to comply with emissions targets, or how it affects curtailments and costs. That process really would take about 6 to 8 weeks to do. And then in addition, of course, as those results come in, we would need a little bit of time to analyze those and write up the results and provide that. So that's where I think in the motion, we got to a period of about, I think, 12 weeks of additional time in that procedural schedule to do that. And that's really, some of these things can be done in parallel, but many of them need to be done in sequence. And so some things are dependent upon others. And so that's kind of at a high level why the timelines are what they are, and why it differs a bit, I think, from what we may have understood from the technical conference.
Okay, understood. And thank you for that explanation. Mr. Pascucci, Mr. Greenberg, who participated in the technical conference, is on with us again today, and he has a few questions just to help us understand a little bit about the Encompass modeling. So I'm going to invite Mr. Greenberg to come on here. He's here. There he is, and ask his questions. Go ahead, Mr. Greenberg.
Good morning, everyone, and thank you, Your Honor. And Mr. Pascucci, I appreciate what you just said, but I got to say I find it surprising, given given what the company was able to do in response to the overwhelming number of bids that were submitted in response to the company's last ERP, and using Encompass to identify. Anyway, the massive modeling that you had to do in a very compressed time frame. And if I could, I think what we're, as ALJ Farley indicated earlier, we are in no way asking the company to develop alternate portfolios. So just want to put an emphasis on that. We're not looking for alternate solutions. We're looking for a better demonstration of need across somewhat altered, further down the demand curve, and also with an altered dispatch scenario. We did not want to overspecify that because you and your colleagues understand the system in ways that we cannot possibly understand it. If we were to try to specify exactly what that dispatch should be, we would probably ask you to model something that is replete with violations that are not physically possible, right? So we didn't want to specify that. I find it difficult to understand why it would take, I think you said 6 to 8 weeks to run an Encompass model where, for instance, you put an artificially high price on the production cost of wind, i.e. add whatever dollar per megawatt hour value is necessary to put that towards the bottom of the loading order, i.e. below the operating costs of the thermal generation within the Denver metro area. Run the production cost model with the existing loads and resources that are already in the model, and do a production cost run to identify the megawatt operating levels of the thermal generation during the peak load hour and at all the other hours, load hours, further down the load curve that we've requested. It's very difficult for me to understand why that would be a time-consuming procedure. And then to take those loading levels on each thermal generator and put those into your power flow modeling. So that would be helpful for me to understand. I think it would be helpful for all of us to understand.
Yeah, thank you, Mr. Greenberg. And Mr. Greenberg and Your Honor, if I may at some point in this punt as well over to Mr. Urquidez, who can provide, I think, a little bit more technical detail where we need it, if that's all right as well.
By all means.
Okay, thank you. So maybe to start, Mr. Greenberg, I'll try to answer your question in that I think what you are proposing to do, and my understanding, having worked with our resource planning team on a couple of resource plans now, putting that information in and setting those functions in an Encompass model, it is certainly possible. I think there's different ways you could go about it, whether you said you set some artificial price. I think you could set units to certain must-run characteristics. What I've seen when we've run these models is a model that you think is going to spit out an answer in 2 or 3 days can often take a week or longer to solve for. And so that's where I say, where we're running several versions of these, it's not always possible to run 6 or 7 scenarios at the same time. Those are things that we usually need to do in sequence where we could run one set of analyses. I think like we talked about in the motion here would be, if you wanted to see under a condition where only, say, the 2025 projects are in service, you'd have to run one Encompass model for that. And then if you needed to layer in additional projects or you wanted to look at additional assumptions, you'd have to run a second one for that. And so that's where the sequencing becomes a problem that adds time
I
to.
need to interrupt you because I think there was a misperception in what you just said, Mr. Pascucci. Again, we're not, let me put it this way. What we are after is the demonstration of robust need pre-mitigation. Okay, so we're not asking for the company to model. This would be in the power flow, I guess, but we're not asking for the company to model the mitigations that it's proposing in the CPCN. We're asking for the company to model its existing system to demonstrate, very similar to the pre-mitigation overloads shown in, well, identical to what's shown in Appendix B of AWS-1 attachment revision 1, right? Now, I just want to make sure that's clear. We are not looking for the post-mitigation case. We are trying to get a better understanding, a broader understanding of the need for the mitigations that the company has proposed. Is that clear?
Yeah, if I could maybe repeat it back to you just to make sure I am following. I think what you're effectively saying is rerun an Encompass model, assuming no transmission upgrades whatsoever are done. And what would the production cost model do in order to achieve a reliable result, or as reliable as you could get, with the assumption that you are unable to deliver the generation or all of the generation approved in the clean energy plan, which would, I think, get to your point of this is how much you would need to run thermal generators. This is what your unserved energy would be in those scenarios. And then look at the scenarios of where are the reliability issues related to running at that maybe enhanced thermal load. Am I understanding correctly?
That is correct. It is, you know, the company is requesting, I forget now, is it 1.1 or 1.2 billion dollars of transmission upgrades, having left off the HCSC, the harvest, I'm not gonna, the harvest to Cherokee line, having left that for later, presumably in the ongoing JTS or a subsequent CPCN, right? So that's why we're down from what was 2.2 billion in 24A-0160E to 1.1 billion in this case. We want to understand, and I think it would really improve the record considerably for the company to demonstrate that the overloads shown for the single peak load hour and a single twilight hour persist, again, at other loading conditions, understanding that you have to plan for the peak load, and with altered dispatch assumptions that the company could choose to use under a specific set of load conditions in limited hours. That's what we're after.
Thank you, Mr. Greenberg. That I think is a very helpful clarification. I think we're understanding better now where you are all intending to go. I hesitate to say, as I don't run the models I don't run the models, but I don't know if this is appropriate for me to ask, but it may be worth us taking a few minutes internally to confer as to that, I think, narrower scope that we're understanding that you're asking for, if that's something that can be done in a more accelerated timeline than what we initially understood you were asking for and had presented.
So that is appropriate. So why don't we go ahead and take a recess to allow you to have that conversation. How much time, Mr. Pascucci, do you think you need? I'm not trying to push you. I'm just trying to be realistic here.
Could we have 15 minutes? Could we
Yeah.
meet back at 10?
Yes, that would be fine. So let's be in recess then until 10 a.m. Thank you. Okay, Ms. Wiesenthal, are you ready?
Yes.
And Ms. Federico?
Yes.
Okay, we are back on the record in proceeding number 24A-0560E. We took a 15-minute break to let the public service team discuss among themselves timing issues. So I see Ms. Shields, you're have your camera on. I'm assuming you want to say something, so go ahead.
Yes, so we've had a little bit of time to discuss at the outset. The first thing I would say is, so in Compass modeling alone, it's not a dedicated transmission planning model, transmission reliability model, or production cost model. Mr. Pascucci is prepared to walk through some of the timeline of the modeling that it would take, or that we've planned, that we've identified that we could do to be responsive to the variance requests that we submitted. That said, at a high level, what I would represent is that at this stage, the company is confident that it can deliver the requested modeling with a 130-day finding of extraordinary circumstances and within the amended schedule that we've proposed. That said, Mr. Pascucci is happy to kind of walk through the modeling steps and associated timeline that reflect how we have gotten to the amended schedule to be able to deliver that modeling.
Okay, thank you. So, Mr. Pascucci, let me just ask you at the outset, I've tried and Mr. Greenberg provided some, I hope, useful clarification on what we're looking for. It almost sounds to me, based on the setup by Ms. Shields, which is very good, that what you're about to tell me is does not reflect the clarification that we've just provided. In other words, nothing's really changed timing-wise. You're just going to explain what's been requested in the motion. Is that accurate? Is that fair? Or have things changed?
I would say, I think, given the clarifications that Your Honor and Mr. Greenberg provided, I can walk you through the timeline. I think there is a potential to accelerate it by maybe 2 to 3 weeks, depending on how much analysis we want to provide. And so maybe it makes sense to walk you through the steps that we would need to go through first, to kind of get to one point and then decide if we would want additional information after that.
Okay. Why don't you go forward then with what you have planned?
So step one in the process we need to go through is developing kind of like I don't think this is exactly the appropriate term, but a nomogram light or a mini nomogram, in which we determine what the import constraint into the Denver metro is, absent any sort of transmission upgrades. I'm not sure that analysis doesn't seem to exist today to understand what the pre-CEP Denver metro import constraint was. So we need to run that analysis to determine that. That takes about 2 to 3 weeks to do, at which point we can then run an Encompass model, assuming an import constraint into the Denver metro area that determines how much of that new renewable generation from the CEP can flow in, if any. And then the Encompass model can also pick up what the appropriate, to Mr. Greenberg's question, what the right levels to run thermal units are. That would take, we think, about another 2 to 3 weeks. So you're at about 6 weeks there, and we would probably need about 2 weeks, we think, to draft up the testimony in response to that. So that would get you to a point where I think to what Mr. Greenberg was asking about, gets you, what does a no Denver metro transmission upgrades world look like? What it would not get us, and I should be clear before I go on to what it doesn't get us, is that would be a 1-year snapshot where we essentially look at 2028, no Denver metro upgrades done, to come up with the results there. What it would not get you is a reflection of the reliability of that plan and whether the company could operate that sort of plan. It would also, as I said before, since it's a snapshot of 2028, not get you a look at alternative, I think, as we proposed in our motion, alternative layering in of projects, which if I understood Your Honor and Mr. Greenberg correctly, you were not looking for that level of analysis. So let me pause there. Now that I've kind of laid out what I think we are planning, or we could be able to do based on the feedback you've provided, and see if that's more closely aligning with the commission's intent here.
Yes, give me just a moment. I believe it is. Yeah, so, okay, and you had said at the outset in response to the question I asked about whether what you were about to present, and you have now, reflected the discussion we've already had about potential efficiencies in light of the information and your information that we've provided and your understanding of it. At this point, I think you said there's a potential for accelerating things by 2 to 3 weeks, perhaps. So did the timeline you just provide not reflect that 2 to 3 week acceleration potential?
Yes, that did. That we think would take about 8 weeks versus what we had laid out in the motion was 12 weeks. So that level of analysis could save, that's what we're saying, about 2 to 3 weeks, give or take. I'm hesitant anytime to commit to a model running perfectly. But I think that would allow us to shave a couple of weeks at least off of this. With the trade-off being that what you would not be getting is that reliability analysis, where our operations team sit down to look at, is this a operational portfolio or not?
Okay, so, and if you added that layer in, are you saying that's included in what's proposed in the motion, the schedule proposed in the motion, and what you just told me would not include that? That's what you're saying, right?
Yes, that's what I'm saying. The motion included that reliability analysis. What I proposed to you just a few minutes ago would not include that analysis. So, and if I can clarify one other item, I think your point one question of running those additional power flow models, that could still be done in that timeline as well. It's just the main thing that we're tweaking here, which is the longest period of time, is that analysis of, I'll say, we've provided Metro on in the model, the assumption that the Metro upgrades are there. What we'd be providing now is Metro off, where the Denver Metro transmission upgrades are not available.
Okay. But as you say, this 8-week timeline would not include reliability analysis.
Correct. Yes, that takes about another 2 weeks on top of running those models to really look at and dig into those results.
Okay. All right. All right, so I appreciate this. Here's what I'd like to do. Let's take another 15-minute recess. I just want to chew on what I just heard, and come back, and we can move forward from there. I want to make sure that I'm not missing anything. So with that, let's be in recess until 10:25. Thank you.
Thank you.
Okay, Ms. Wiesenthal, are you ready to go?
Yes.
And Ms. Federico?
Yes, I'm ready.
Okay, so we're back on the record in proceeding number 24A-0560E. So let me just thank Ms. Shields and Mr. Pascucci in particular for providing clarification and information regarding the timeline. I mean, it makes sense to me. You're obviously in sole possession of information about how fast you can do. I trust what you've told me and accept it. Let me just say that the analysis that we're requesting in the supplemental direct testimony, we need and want, but need the reliability analysis. So that will have significant value potentially in any event to the decisions that I'm going to have to make ultimately in this decision or in this proceeding. So having a reliability analysis of the conclusions that will be generated based on the data we're asking you to produce. I mean, basically, can public service reliably run its system based on the outcomes we're asking you to reach with the analysis we've requested? Anyway, the reliability analysis is very key. So I want public service to do that. As I understand it, and I know you've been hit with new information today, and are probably reluctant to really commit to cutting time off. But as I understand it, what I've been told is with the reliability analysis and in light of what you've learned today from us, you still basically need the schedule that's been proposed in the motion for variance. If you did not do the reliability analysis, you could cut 2 to 3 weeks potentially off of that. But with the reliability analysis of what we're asking you to do and produce for us, you need basically the timeline involved with the schedule you propose. So, Ms. Shields, Mr. Pascucci, if I understood correctly what Mr. Pascucci told me just before we took this this break.
Yes, Your Honor, I believe that's accurate. And I would say throughout that discussion, we did not indicate time that would be needed to actually draft the supporting testimony, which we'll obviously endeavor to do in parallel. But is the lawyer that wants to make sure we have a robust record, also want to make sure that the company does have sufficient time to be able to draft the testimony supporting all of the analysis.
Yeah, and I think that was included in what Mr. Pascucci told me earlier. But the bottom line is that with the reliability analysis, you're not confident you can shave time off of what was proposed in terms of the schedule and the motion for variance. That's my understanding.
That is correct.
Okay, all right. So that's helpful to know. And let me just also be very specific. What we're looking for, at least with respect to the first two topics, I think that's right, is, we use the word replicate. You changed that replicate word to reproduce, I think. In any event, we're looking for Appendix B, which provides overloads, your conclusions analysis for overloads in 2025, 2026, 2027, and 2028. And I heard Mr. Pascucci tell me previously that, what we've gotten to today, you would be providing basically the same thing through 2028, but including all 4 of those years. Did I understand that? And only with respect to pre-mitigation. So do I understand that correctly? I just want to make sure we're going to basically get the same data with the pre-mitigation case, with the assumptions we've asked you to use for 2025, 2026, 2027, and 28. I understand that correctly? Mr. Pascucci, maybe you're the best one to answer that.
I will also ask Mr. Urquidez to weigh in here. I think when we looked at, and I wrote down here the topics. Topic one was, how often do the overloads occur? And I think that's where you could ask. We'd done, I think, the peak hour, and then you asked for like the 5th, the 20th, the 100th, and the 200th. I think running the power flows to determine how the persistence of overloads occur. And Mr. Urquidez, please correct me if I misstate. That is something we can do within the proposed timeline. What I wasn't clear about there was in the topic 2 and 3 to see how dispatch changes occur. What we can provide in the proposed timeline from our motion would be a 2028 peak look, as well as likely a 2028 overnight and 2028 twilight look. What we would not be doing is looking at a 2025 peak and overnight, 2026 peak overnight, etc. in each of those years at the like 5th, 20th, 200th, and 100th. So I may be overcomplicating it. I thought what I just heard a moment ago was that you were looking for those power flow models under multiple different years, under multiple different kind of metro on and off looks. And I think that was where I'll pause and let Mr. Urquidez jump in just to make sure I'm not misrepresenting modeling that we thought we were proposing here.
Yeah, yes, Your Honor. Can you hear me well enough, sir?
I can, thank you.
Okay. Perfect. Thank you, sir. Yes, I think Mr. Pascucci described that well. I will just kind of sum in saying item 1, really, as you described, sir, was a small variance to just identify, yes, we're reproducing Appendix B, and we are doing so with all the requested load changes, and we can do that within the proposed time. In item 2, we will be able to support that power flow analysis with all the requested dispatches. Within that obviously has some combinatorial effects of dispatches. Plus, I think it's paragraph 15 also describes applying those various dispatches to the various load variations as well. So that obviously has a combinatorial effect. That is also something within this time frame as proposed in the motion. Most of our conversation today has been really targeted item 3, which seeks to better understand for the record the impact on the statutorily mandated emissions reductions. That's when we get into the economic analysis. That's when we start talking about the Encompass modeling and so forth, right? So just to be clear, items 1 and 2 from the decision are already included within that time frame, and we'll be reproducing Appendix B to show the various years, 2025, 26, everything that was tested and produced in Appendix B. Item 3 is really where that additional modeling takes a lot more time, and that is where Mr. Pascucci, previous to this previous break, identified 2028 for peak and twilight. That was done in the original study supporting this proceeding. So it would not be the various years or various load profiles that were requested in items 1 and 2. To just be very succinct and clear in that. I hope that helps, Your Honor.
It does. Thank you.
Sir.
All right. I think I have enough. on this now. The bottom line is, I'm not going to rule on the motion for variance. I'm going to give UCA through noon on Monday to file its response to the motion for variance. But I also have, well, I have some follow-up questions for Ms. Shields regarding the motion for variance, but I see Ms. Crampton has her hand up, so go ahead, Ms. Crampton.
Yeah, thank you. And this may be the court's question. I guess one thing that's come to mind based on the court's clarification earlier about what it intended, sort of my question was, are these variance requests necessary based on the clarification, right? They were predicated on an understanding of a request for alternative transmission portfolios. I think that the way that I'm understanding things right now is that 1 and 2, like variances for issue 1 and 2, may not be variances based on what the court clarified earlier. It sounds like request number 3 still constitutes a variance, but I guess I'm seeking clarification if the company believes its requests may be moot based on the clarification provided by the court here today.
And that's the question that I had for Ms. Shields, at least with respect to the first 2 topics. In light of what you've learned today, I guess same question as what Ms. Crampton just posed is your proposed variances from the first 2 topics, are they still necessary in your view? I don't think they are.
I think why I'm pausing is that we have a written decision that says certain things. I think for the first and second requests, we would still stand by the slight modifications to the decision that we are requesting. I am working to confirm as we speak on subpart 3 whether our variance request still stands as drafted. And may need a moment to confirm with the team.
And you can have a moment. I'm going to push a little bit on the first 2. But I'll give you a moment to confer.
And thank you for your patience. Just a moment. We are adjusting to a new office space at Excel Energy, which has a little more distance to travel. So 1 moment.
Let's go off the record.
Your Honor, we are back and ready to go on the record when you are.
Okay, let's go back on the record. So go ahead, Ms. Shields.
Yes, so I think the company, based on the clarification that we've received today, that we would be comfortable withdrawing the first two requests for variance. With respect to the third, however, we believe that we still need a variance. And that would be from paragraph 16 of the interim decision. And largely that is because of the concerns that Mr. Pascucci and Mr. Urquidez most recently just brought up regarding the all 200 highest load hours in each year of the study. So at this point, we would be willing to withdraw our first and second requests for variance, but continue to stand by the third request.
Okay, give me a moment to catch up on the third one. Okay, Ms. Shields, I mean, I see a couple of items that you've added to paragraph 16 are operational costs and renewable curtailments, which I think are basically two data items that we had not been asking for. Is that a fair characterization, at least in part of the changes here?
I think we would be willing to remove those from the ordering language. Originally, we had contemplated that that would be something that we could potentially add, but based on the discussion today, that is something that we would be willing to remove those two elements.
Well, I mean, do you think that that would be helpful information in this record? I mean, in other words, what we were looking for was, if you use the revised assumptions regarding dispatch that we proposed, we wanted information about Public Services View about its ability then to comply with its statutorily mandated emission reductions. That's what this focused on, and you've kept that in there. But you've also added, the impact of changing those assumptions on public services operational costs and renewable curtailments, which has an impact on operational costs as well. I can see an argument in favor of the notion that having that information in the record would be helpful. Was that your original intent? Do you think that's mitigated or eliminated at this point in light of the clarification that we've provided?
Sure. And so I guess how I would respond, we are the applicant, we have the burden of proof. So we would be comfortable leaving the variance as is. That said, we would also be comfortable ending the proposal and ending that sentence after carbon dioxide emissions with a period, and leaving to the company discretion as we move forward with this modeling to determine as the applicant with the burden of proof whether we think that one, timing would permit those additional, and two, whether we think that the record will be best served by providing that information. I would say for ease, since we have filed the motion as drafted with that proposed additional language, we are willing to continue to offer to include that variance in the language.
Okay. All right. In any event, Well, let me just ask this. I mean, this one, you've added language about assumed alternatives with lower levels of transmission expansion. It sounds like you stand by that. Well, I think what the record reflects is that you're standing by the proposed variances in paragraph 35 of the motion for variance. So we can just leave the record there. I know we've got a big record here today that you're trying to include in your responses to my questions, which may be difficult.
Yes, we
So
have. And again, if we had just a moment or two, I could continue to confer with my colleagues.
yeah,
Understanding we're taking a lot of everyone's time, but I do think that everyone will be best served if we can attempt to get this right, or at least as right as we can today.
take the time you need.
And Your Honor, we are back and ready to provide an answer. Which is that the company will continues to stand by its requested modifications to paragraph 16 is articulated in paragraph 35 of the motion for variance that we filed yesterday.
Okay. All right. Just to summarize, it sounds like Public Service has withdrawn the requested variances, and let me just get them for purposes of the record in paragraph 18 of the motion, as well as in paragraph 27 and 28 of the motion, but you're standing by the requested variance in paragraph 35 of the motion.
Yes, that is correct.
Okay, great. So thank you for that. With that, I'm going to hold off on ruling. I'm going to, as I said, give UCA until noon on Monday to file a response to the motion for variance. So I think that deals with the motion for variance for now in any event.
Yes, thank you. And did I understand correctly that it would be your intent to rule on this by approximately next Wednesday?
Yes.
Thank you.
So let me move on to the original purpose of this hearing, which was to address whether there are extraordinary circumstances under section 40-6-109.5 subsection 4 for an up to 130-day extension of the statutory deadline in this proceeding. And I'll just read into the record what 40-6-109.5 subsection 4 states. It states, the commission in particular cases under extraordinary conditions and after notice in a hearing at which the existence of extraordinary conditions is established may extend the time limits specified in subsections 1 and 2 of this section for a period not to exceed an additional 130 days. So I provided the notice in decision number R25-336I required by this statute. The statutory deadline has been extended up until this point as far as it can be in previous decisions. In short, I'm going to conclude that, we're in a ripe position to address whether extraordinary conditions exist, justifying an up to 130-day extension, further extension under section 40-6-109.5 subsection 4. If anybody disagrees, I'm willing to listen. Okay, I'm not seeing anybody pop up. So the parties have previously stated when they proposed the schedule in this proceeding that a 30-day they would support and believe that there were extraordinary conditions to support a 30-day extension of the deadline for a final commission decision pursuant to the statute. And at that time, I believe it was stated that the extraordinary conditions were the commission's docket congestion and the conflicting schedules of the parties' counsel and witnesses, which justified the parties proposing a schedule that had a hearing approximately 30 days later than what I had indicated was the last date on which the hearing could conclude. In my view, I think those extraordinary conditions continue to exist. What's changed and what constitutes an extraordinary condition, I'm going to find that it is, are all the issues surrounding the supplemental direct testimony. It's basically been requested 3 times. We're now on the 3rd time, and we still have not obtained the supplemental direct testimony that we've been looking for all along. And so that has substantially delayed the proceeding. As everybody knows, the commission initially requested supplemental direct testimony. I then added to the topics to be addressed by the supplemental direct testimony. We got that supplemental direct testimony. It was frankly, wide of the mark, which caused me to again request supplemental direct testimony. Now, I'm not casting blame here. It's fairly clear that public service did not completely understand what the commission and I were looking for with our previous requests. So that contributed to the need to request again supplemental direct testimony in the most recent decision, R25-0336I. I believe it was in that decision. So I think today has been really productive. I think the technical conference was very productive in allowing me and Mr. Greenberg to understand what public service can do in terms of modeling, and for public service to understand with more precision what we're looking for. So as I said, I'm not necessarily casting blame about the delay in getting the supplemental direct testimony that we've been seeking. The reality is that the direct case is not currently where I believe it needs to be in order for me to be able to make a fully informed decision ultimately. And that constitutes an extraordinary condition or circumstances justifying a full, in my view, 130-day additional extension of the deadline. So let me pause. I've already made the finding, but I'm willing to reconsider it if anybody thinks that I'm wrong about the existence of extraordinary circumstances justifying a full 130-day extension of the existing deadline. Does anybody disagree? I'm not seeing anybody jump up. But why don't I get on the record from each party whether you support or do not oppose the existence of extraordinary conditions or circumstances justifying the full 130-day extension of the deadline permitted by section 40-6-109.5 subsection 4 of the Colorado Revised Statute. So I'll start with public service. Do you support the finding and conclusion I made, or just don't oppose it?
Recognizing that the company has a pending motion for variance and a pending motion to amend the procedural schedule, yes, we would support your finding of extraordinary circumstances. But again, acknowledging the two pending requests.
Understood. So let me move on to staff.
Thanks, Your Honor. Staff also supports the finding of extraordinary circumstances.
Thank you. Let me move on to UCA.
UCA likewise supports the finding. Thank you.
Okay, and I'm still not seeing anybody from Tri-State here. So let me move on to Mr. Hefner.
Your Honor, Tri-State does not oppose the finding. Thank you.
I apologize. I'd lost track that you're here, Mr. Hefner. And then, are there any other parties present? I'm not seeing anybody else. Okay. So thank you for that. So finally, let me, so I'm gonna withhold judgment on the motion for variance, at least the variance part of it. What I'd like a little bit of input from you on is the proposed schedule in light of the 130-day extension. So you have proposed a hearing from November 4th through 6th. What would be preferable is having a hearing the preceding week, October 28th through 30th. I'd like to hear input to the extent you have it at this point about whether that works for counsel and witnesses.
To clarify, you indicated October 28th through October 30th.
That's correct.
If we might have a moment to confer as quickly as possible with the relevant team.
And if you need more time, if we need to take a formal like 10 to 15 minute recess, I'm happy to do that.
I would suspect that most council and parties would need to confer on this. So perhaps we do take until 11:15.
Yeah, why don't we say until 11:15? We'll be in recess until 11:15.
Thank you.
Thank you. And just for clarification for everybody, sorry, let's go back on the record. That's basically, well, that's the major change that I'm looking to make. And, the statement of position would be moved up by a week. I would keep the same deadlines for the supplemental direct testimony, answer testimony or rebuttal. There would be, what I view in any event is minor changes to pre-hearing motions and responses to pre-hearing motions and deadlines for those, just to fit them in before the hearing starts. So So everybody has clarity. But what I'd like is an answer to the question of whether counsel and witnesses are available October 28th through 30th. So now we'll go
Thank
in
you.
recess.
And again, with all other dates beside, for instance, responses to hearing motion, the settlement deadline, all of those remain the same.
Yes.
Thank you. Yes, we will confer.
Okay, so we'll go into recess until 11:15. Thank you. Okay, Ms. Wiesenthal, are you ready to go?
Hear me? Oh.
Yep, I hear you now. Thank you.
Okay, sorry, my mic was.
That's all right. And Ms. Federico?
Yes, I'm ready.
Okay, we're back on the record. And proceeding number 24A-0560E. Go ahead. I'll start with you, Ms. Shields.
Yes, so we've conferred with our witnesses. The company is amenable to running the hearing October 8th to 28th to the 30th. We will propose moving the deadline for the cross-examination matrix and pre-hearing motions to October 23rd and the responses to pre-hearing motions to October 27th. And then I would note in the event of a settlement, we might consider filing a motion to amend the schedule to perhaps hold the settlement hearing on October 30th or one of the later of the days scheduled for hearing, but can do that in such event.
Okay. All right, so you'd like October 23rd for deadline for pre-hearing motions and the 27th for responses there too.
That would be our proposal, yes.
Okay, all right. So everybody else, does anybody have any problems with counselor witnesses being able to attend the hearing from October 28th through 30th? Not hearing anybody say that that poses a problem. Does anybody have any other comments or proposals regarding this proposed schedule and my proposed revisions to it? Ms. Crampton, go ahead.
Thank you. I just wanted to flag, I don't know if this is an issue for other parties, perhaps staff, but there is a pending proposed procedural schedule in the Black Hills Clean Heat Plan that has an evidentiary hearing on the 27th through the 29th of October, as well as an SOP deadline of November 14th. I don't know if the court's familiar, but that was a case that had reached a settlement, and the settlement was effectively rejected. So I do expect that case will proceed to a hearing. I am counsel on both that case and this case. I would certainly prefer the proposed schedule that the parties have offered in this case. However, if the court can't accommodate it, I think UCA can work internally to make these court dates work with this proceeding and the Black Hills proceeding. But if that is the way the court is inclined to proceed, and kind of piggybacking off Ms. Shields' statements, I would request that any settlement hearing, if a settlement's achieved in this case, be scheduled for the 30th, as opposed to the earlier days, just to accommodate what I think will be the schedule in the Black Hills case.
Okay. All right. Give me just a moment. Okay. I understand that. Thank you for that input, Ms. Crampton. I understand it. So let me ask, I think Mr. Cox, did you want to say anything? I just want to give everybody the opportunity.
Yeah, I was just going to say that staff, the hearing dates would work. I think I would echo Ms. Crampton on the 30th for a hearing in the case of a settlement. Obviously, if there is a settlement, that only gives us a couple days to prepare for hearing after getting settlement testimony and getting the matrix. So pretty tight there. So yeah, if that's possible to plan for a hearing on the 30th, if there's, in the case of a settlement, that would be, I think, helpful.
Okay. Thanks for that. So anybody else? I'm not seeing anybody pop up. So I'm assuming nobody has any other comments regarding the proposed schedule in the motion for variance as revised by me. So I'm going to take this under advisement. I just ask all of you to, keep your dates open for October 28th through 30th until the written decision comes out, which will be next week by Wednesday, hopefully anyway. Okay. So I'm at the end of what I wanted to address here today. Does anybody have anything else they'd like me to address? I'm not seeing anybody pop up. So with that, let me thank all of you, counsel and witnesses, for your help here today. I think this was productive. I think we have a better understanding, both me, Mr. Greenberg, and everybody else, about the future direction of this proceeding. So with that, I'll thank you again, and then say we're adjourned. Thank you.
Thank you, Your Honor.